Okay, I'm Leslie with the New Mexico Small Business Development Center, here with Anna Lena with me, also with the New Mexico Small Business Development Center. And we're excited because this is the second part of the two-part series, Top 10 Mistakes Businesses Make, or something along those lines. So on Monday, we had 10 through 6, so we're climbing up the ladder. So this is going to be some great information. This is going to be 5 through 1. Again, if you have questions, just type it in the Q&A. Larry will just, he's been doing great at picking up those questions and making sure that everyone gets their questions answered. So I will turn it over to Larry Donahue for part 2.
Thank you, Leslie. I appreciate it. Hi, everyone. Thank you for joining us today. This is part 2, and I'm going to quickly go over part 1. So if you missed part 1, that's okay, although you're not going to get a lot of the detail. But at any rate, my name is Larry Donahue. I'm a lawyer. I've been an attorney for about 27 years, and I've had an opportunity to see over and over again what some of my clients what kind of problems they seem to run into and what some of those common issues are. And that's what this is about today. Before I start, though, I just want to remind you, please mute your audio. You might want to set your Zoom ratio to fit window to help maximize the resolution and the clarity of the presentation. Q&A will happen throughout the discussion. So I love to see that people aren't falling asleep with my boring voice. So please type in questions. I'll do my best to answer them. And then we'll also have a Q&A session at the end for a few minutes and try and address some questions then. So at any rate, let's get started. And what we're going to be talking about is the top 10 legal mistakes. And I'm going to focus on numbers 5 through 1 in the second part series. And they are mistakes that can and do destroy businesses. And before I begin, I want to remind you about all the great content and material that the SBDC has available. You can go to the website, and on the upper right, there is a menu for some of their webinars. And you can see here, starting on March 1st through March 5th, there's a lot of good topics. I'm going to be teaching the March 1st one, about operating agreements. Those are documents for LLCs, and I'm going to kind of go into detail about what they are, why they're important, what you want to do. I'll try and make it fun and give you some examples, real world examples of issues that we've seen with the operating agreements. And I'm going to do that today too as well, regarding the top 10 mistakes. So the first part of this was done on Monday, and I went over numbers 10 through 6. And we're going to do a replay of this that will be available on YouTube shortly. So if you want to see that and you didn't see it, you'll get an opportunity to do that. This is part 2, and we're going to start at number 5 and move our way up to number 1. But before I do, I just want to quickly go over what part 1 was all about. And that you see here in front of you. Number 10 was ignoring the professionals. Specifically, I always recommend that businesses have at least 3 professionals at their disposal at all times: lawyers, CPAs, and bankers. Number 9 was operating as a sole proprietorship or partnership versus a corporate entity. The most popular are LLCs and corporations. Number 8 was poor business naming choices. Everybody falls in love with a name, and usually it's very descriptive, which means it's hard to find you in Google, or somebody else might have the trademark, and you might be dealing with a trademark infringement lawsuit later on in life. Number 7 was not understanding copyright law and what a work made for hire is. And the quick answer there is you do not own the copyrights of the work product produced by people you pay, unless they're a W-2 employee. So contractors and vendors will own the IP, the intellectual property of the work product you pay for. Number 6 was no or poor contracts with third parties. And contracts are just really important. They establish who's responsible for what. when do you need to pay, how you can get out, and they are going to be both the nemesis and the savior of your business, depending on how you take them or deal with them. But let's go to number 5, partner disputes and no or poor formation documents. And I got to tell you that each one of these bullets you see here, I've had to deal with as a lawyer. And they're as tough or worse than a divorce. And you can almost imagine that, can't you? Because businesses are a lot of work. People put their blood, sweat, and tears into a business. And if you don't have the right partner, you can have an absolute tragic set of circumstances happen, very difficult fight. And so it's interesting because you can form a partnership very easily and quickly, and a lot of us do so without thinking through the implications like you would a marriage. But you really need to do that. And you need to think about all these issues here. You know, what happens if your partner's a narcissist or dies or becomes incapacitated? Or insists on hiring family members, or wants to kick you out of the company, or doesn't do their job that they promised. Or maybe it's not as outrageous as this. Maybe it's just you burn the midnight oil and you work 80 hours a week and your partner doesn't want to work more than 30 hours a week. You know, what do you do with those kinds of things? So what you have to recognize and understand is that there's very little that the law has in place to protect you against a bad partner. So what that means is you really need to have the proper formation documents, the partnership documents. And for example, that would be an operating agreement for an LLC. That would be the bylaws for a corporation. And I've listed some optional documents here that are very important depending on the circumstances of your business. For instance, a buy-sell agreement would help identify when you can force certain buyout options under certain scenarios. If somebody wants to leave or they die or become incapacitated. A restriction agreement prevents your partner from selling their ownership to somebody else without your approval or your right of first refusal, meaning your ability to buy their ownership before they sell it to somebody else. And then a purchase agreement, for instance, every day, I talk to somebody that says, oh, I want to make ownership available to employees. And I just want something quick. I don't want to spend a lot of money. And then I ask them, well, if they quit, do you want to get the ownership back? Or if you need to terminate them, do you want the ownership back? And invariably, the answer is yes. So that's called a clawback or a buyback. And there's a lot of parameters around how that might work. So you really need to be careful about entering into a partnership and having the right documents in place to identify how the business is run, what happens when certain edge cases happen. You have to remember that the law has nothing in place to protect you against a bad partner. So there's very little you can do in the face of bad behavior. It's very difficult to remove a partner and enforce your rights if you don't have a pre-agreed mechanism to do so in the formation documents. The law on LLCs and corporations is very high level and very general and does not discuss things like what happens if the partner doesn't want to work for the company. You're just not going to find that in the statute. So you need to have that in contract. The other thing I want to tell you is do not just walk away from your company if things are really bad. You have to have some sort of separation agreement. Otherwise, you are still exposed, and then you are potentially responsible for the harms and activities that business does or your partner does, and you're not around to, minimize the harm or the damage. And so I want to give everybody a real world example to these things that I'm bringing up. And this real world example, remember, you saw those lists of potential problems. I had clients for all of those. I've had sons beating up fathers. I've had daughters locking mothers out of their business. I've had if you can think of a crazy situation, I've had it. This one really makes me sad, and I tear up sometimes thinking about it. I had a client who had a business, and I can't say too much about it because some people might figure out who it is, and I can't do that. But it was a successful business in the Albuquerque area, had a great name statewide, and he had a partner who was an actual CPA. That partner acted as the CFO for the business. They owned it 50-50. And it turned out that CFO started keeping a second set of books. And so there was the set of books that my partner had access to and gave me. And then we were able to identify a second set of books through a forensic accounting, which was extremely expensive. And the reason this makes me sad and kind of gets me teared up a little bit when I think about this, was that my client died in the middle of the dispute. And what happened is he got really depressed. He's spending a lot of legal money. His partner was doing a lot of really shady stuff. And I'll give you an example of one shady thing. In the chart of accounts for the company in the expenses, there was a line item for office supplies. And specifically, it said computer keyboard, monitor, and a couple of other computer pieces of equipment. Do you know who the vendor was? Kohl's. Well, if you've ever been to Kohl's, you'll know that they don't sell computer equipment. They don't sell keyboards. So this CFO was lying about company expenses to that level of detail. And, putting office supplies, even though the vendor name didn't match what was actually being purchased. And so we hired forensic accountants to go in and look at, and this is a major multi-million-dollar business. And we found, 40% is a little high, 30-something% of the expenses were fraudulent. And we found out he paid for a pool at his house, golf clubs. He was literally milking the company for everything he can, to the point where it was struggling to meet payroll. And the CFO was obtaining very expensive financing. And so he would bring money in, move it around at other accounts, and it was creating a big mess. And my client ended up committing suicide during the heyday of all of this. And so he was just really a nice guy, lovely person, and to have that tragedy it's been very difficult for me. And it just goes to show you how traumatic a partnership problem can be for you. So you really need to treat a partnership or partners like a spouse and be that discriminating and that careful when you deal with that. And then, of course, have the right formation documents. So you have the ability to leave the relationship and terminate the partnership if you decide to do that. So let's go on to more fun topics. Number 4, signing contracts without reading or negotiating. And you need to understand, you don't need to be a lawyer to look at a contract. There's really basic things you should do even without us lawyers. For instance, do you have the proper legal names of the parties? If you have an LLC or a corporation, it shouldn't have your name, personal name, listed as a party. That's a great way to make yourself personally responsible for the company. You don't do that. Even with a lease, when the landlord says, oh, no, you need to be responsible, that doesn't matter. The LLC is the tenant. The LLC is the contracting party, and you may have to sign a personal guarantee or something else, but you don't want to be a party to the contract personally if you have a corporate entity. And that's an easy check. All of you can do that easily enough. But look at these other bullets. Are the promises mentioned in detail? And why do I say that? Well, if you were in the first part 1, I talked about how verbal promises are overridden by the written language of a contract. So if I have you sign a contract and there's something really important to you that is not in the contract, and I verbally say, oh, don't worry about that, we'll handle that for you. No, can't do that. And what I mean by that is My verbal promises mean nothing, even if I directly lie to you. And even if you have evidence of that, doesn't really matter. I mean, I don't want to say it doesn't matter. We could fight about it in court and you can spend thousands and thousands of dollars and maybe we'll win, maybe, but it's a very difficult legal argument to have. So you want to make sure that the promises, the important promises, are in the written document. Also, ask yourself, what could go wrong? Call them edge cases. And does the contract address them? Are the dates and dollar amounts correct? Are there too many promises here that you have to fulfill? And are you able to fulfill them? And are you in control of the things you need to fulfill? Meaning, if there's a requirement in there, it says you need to do X, but you don't have the ability to do it, the other party does, look for that. Just logical consistencies. Is it fair and balanced? Are there long-term implications here? Is there, how do you terminate if you want to terminate? Just look at every document and make sure it has these issues and set up correctly. You don't have to be a lawyer to figure all of that out. And then, of course, we're in the age of pandemics, and everything I read tells me, this is going to be a more ongoing thing. And so ask yourself, what happens in a pandemic? And you also ask yourself, if the pandemic lasts 3 weeks or 2 months, maybe you can defer or suspend the contract. But if it goes on for a year or 2 years, do you want to suspend the contract or do you want the right to terminate the contract? You need to think through those issues and what's best for your business and make sure it's in the contract. These things should really upset you. And I want you to get mad if this ever happens to you. And read these bullets. If anybody hands you a contract and then tells you what's in it, I'm not exaggerating when I've said I've had clients that were lied to their face. The contract said the exact opposite of what they were told was in the contract. And guess what? The other parties, I never said that. I wouldn't do that. The contract is the contract. And then what do we do? So it's your word against theirs. And we have something written which really goes against what it is we're trying to say. You should get mad at the second bullet. When anybody tells you, I know it's not in the contract, but don't worry, we'll take care of you. No, that's a prelude for disaster. Put it in the contract or don't sign it. The other thing I love is when people put pressure on you right away. Well, you better sign this now or we got somebody else in the wings. You just need to hand them the contract back and say, go get that other person. You need to give me time to review this. And ideally have a lawyer or somebody review it. The other thing you should be really wary of is somebody who represents both parties. And apologies to any brokers here that are paying attention, but if a broker is representing both parties, they're really not zealously representing either one of them. They're trying to get the deal done. And there's a lot of really good brokers and they are, conscientious and try to do the best thing they can for both people. However, how do you figure out whether you have a good broker or a bad broker? And I got to tell you, we lawyers, we can't do that at all. That's called a conflict of interest. And I'll give you a very simple example. If I have 2 clients and I'm representing both of them and they do a deal together and it involves money, well, the party that's receiving the money, I could argue, should have a security interest agreement. It should have some collateral so to make their position more secure. Well, by arguing collateral, I'm doing that at a disadvantage to the other party. So do I argue collateral or not? Whose side am I on anyway? So we lawyers can't do that at all, but brokers can do that. And so you need to be very careful about that. Also, people who are doing like lead gen and referrals, certain partners, what you'll find is they, if you aren't careful, they'll create conflicts of interest for themselves. And what does that mean? Well, they'll introduce leads to you, but only those leads that are going to pay them for the introduction. So they're really only giving you a subset of the possible leads available. So you really need to think about that a little bit and prevent people from representing both parties in most circumstances, in my opinion. The other thing is you want a contract that awards attorney's fees to both parties. If it's only awarding attorney's fees to the other side, you should get upset about that. It's a one-sided contract. The other one is like if there's a lot of penalties for you for breaching, but no penalties for the other side. And then if it's very specific about you and you got to pay, but then it's not very specific on the other side on what they got to do, you need to be upset about that. You know, it's very easy to say, hey, you got to pay me $5,000 a month and I'm going to provide marketing services for you. What is marketing services? Is that, am I running Google AdWords? And if so, am I paying for those Google AdWords or do you got to pay for them? Do I pay them out of the $5,000 you're paying me or just a portion of that? Details matter, especially when you're paying good money to get some services back for your business. So I have a couple of real world examples here. And the dentist's office is an example of one that I kind of mentioned. He is a good dentist in New Mexico, doing very well for himself. And he signed a contract for a marketing company out of Boston, Massachusetts. And I don't remember the exact dollar amounts, but it was a lot. I think it was somewhere around $25,000 a month he was paying for marketing services. And the contract literally said marketing services. And it turns out, surprise, surprise, that he was not getting enough leads in business to pay for that $25,000. And so he eventually wanted to get out of the contract, but it was written such that it was very difficult for him to get out and very expensive. So it was really just preying on people, making these empty promises about marketing, and that dentist ultimately had to go out of business. I mentioned the $19.95 per month credit card processing machine for a reason. I had a client who signed a contract literally for $19.95 for a credit card processing machine. And the reason I think it's instructive is that $20 a month is not a big deal for businesses. So we tend to, it's $20 a month, who cares? So we sign on the dotted line. The problem is it was a 10-year contract. My client went out of business, and I want to say it was like year 3. And so he continued to pay the $20 for like another year. And he tried to cancel the service. They weren't very responsive. He lost track of where to send the money. And so somewhere around year 4.5, he just stopped paying. Now, you would argue, well, you probably shouldn't do that, but it's a small amount of money. It was very inconvenient for him. And it turns out that there was a lot of fine print in this contract that you almost couldn't read because it was faxed back and forth and it was just really poorly written. But it allowed the credit card processing company to start charging significant fees and penalties and interest. And so what ended up happening is around year 6 or 7, a lot of expense built up. And we're talking about for a $20 a month contract, it was over $10,000 worth of fees. So what this company did is obtained a judgment in New York, the state of New York. So they filed a lawsuit, they got a default judgment, and then they went and came to New Mexico and what's called perfecting it in a new state. Then they went and started seizing bank accounts and garnishing his wages for thousands and thousands of dollars over this $20 a month contract. I see we got a question that came in.
We do, Larry. And I have a question also. So
sure.
Do you want to go ahead and read this question first?
Sure. Do you recommend suggesting alternative language to address your objections or clarifications during the initial discussion? The answer is absolutely. A contract is a meeting of the minds between the two parties. And so if you don't understand something in the contract or it's not to your liking, definitely discuss it, negotiate, and put the right language in the contract, if I'm understanding your question properly. And was that Leslie that you're asking a question?
Yes, I was also asking because I was really interested when you were talking about this is that I have seen a lot of MOUs, which is the Memorandum of Understanding between different organizations, especially now. Would that be something along? What would you think of that?
I think they're great. Um, However, I did have an issue with a client where the title of the document was MOU, Memorandum of Understanding, but it was not an MOU, it was an actual contract. So be careful with the language. At the end of the day, there's two components of a contract. There are the business issues and the legal issues. And me, Larry, the lawyer, you don't want me dictating the business issues to you guys. So it's great for the business leaders to negotiate what all the important terms are. And then Larry, the lawyer, or whomever you hire to help you draft the document, can address the legal issues. And a memorandum of understanding, a letter of intent, non-binding, are great documents to help you flesh out details on important contracts. Absolutely. Did I answer your question, Leslie?
I think so. Yeah, I always want to jump in. I never know if it's okay, but
Oh,
uh,
please.
I do.
I'm not going to dwell on the other two examples, but I want to tell you one is the wrong liquidated damages clause. So there are a lot of templates on the internet. Some of them are good, some of them aren't. But if you're going to download a template, you really got to read the darn thing. And the reason I'm bringing this one up is my client downloaded a contract off the internet. It had a $200,000 liquidated damages clause in favor of the other party. So my client thought he was okay in terminating, and it turned out he then awarded a $200,000 liquidated damages to the other party. He thought it applied to him, but in reality, it applied to the other party. So that would be a very expensive mistake to make. The other thing on the $20 million property loss, there is a law in New Mexico, the doctrine regarding notice. So if you have an evergreen contract and you want to have it automatically renew, and if there's a notice provision saying, I have an option to renew, and I have to invoke that option within this time period, or I lose my ability to invoke the option. So let's say you had a land lease and you put a $20 million building on that land, and that land lease is 10 years, and you have another option to renew it for another 10 years, and you have a 30-day window after 9 years and 11 months to renew that contract. Well, in New Mexico, the law is if you're off by a day, you lose. So notice provisions are extremely important in contracts because of the way New Mexico law interprets that. So don't let that happen to you. And don't just rely on Outlook calendar, by the way, because I use Outlook a lot, but every once in a blue moon, I will see a calendar item and it'll just randomly disappear. And I ask my IT staff, what the hell just happened to that really important meeting that I had? It just disappeared. IT doesn't know what happened to it. So I actually use Outlook, and then I have a separate manual calendar that I keep track of really important dates. And I'd recommend you do the same thing. Number 3, doesn't this seem so obvious? You shouldn't do things incorrectly or illegally. You'd be surprised though. So here's what you need to know. The state of New Mexico is not your friend. I'm not trying to knock the beautiful state of New Mexico, but the government sometimes is a little, they just have their blinders on. And so they're really not looking out for you. And what do I mean by that? Well, if you get an LLC, for instance, from the Secretary of State, don't for a minute think that the Secretary of State is saying, oh, well, you can operate a medical practice. No, the Secretary of State doesn't check to verify you have an appropriate medical degree and medical license to practice medicine. So they don't do that analysis. And there's another question that came up. Let me get this real quick. Looks like New Mexico rules and regulations are tougher and more complicated than other states. Yes and no. There are some, an example is contractor law. If you do improvements on property without a valid license, you run significant risks. You can be financially penalized, and you could have to pay for the fixes of the improvements. You could lose all the money you put into those improvements. Other states like Texas don't have strict licensing requirements. But at the same time, New Mexico is a little bit like the Wild West in that there's a lot of law that isn't very mature or sophisticated like you might find in California, Illinois, New York, or Florida. For instance, franchise law is not as sophisticated here as in other states. So New Mexico has a lot going for it. And some of the things I'm raising here, I don't think are unique to New Mexico. I think all states have these problems. And like the example I brought up with the LLC, forming an LLC, they're just forming an LLC for you. They're not telling you how to pay taxes correctly. They're not telling you about licensing. So you really need to be careful about that. Just because you get a business license doesn't mean you could do whatever it is you're doing. There may be other laws and other requirements, laws regarding licensing, permits, insurance. So there's a lot of different pieces to the puzzle. And what I want to warn you about is a false sense of accomplishment because you got a business license, hurrah, but that doesn't end the analysis. What are you doing? And are there regulations and rules around licensing and permitting or other issues that you have to investigate? And I got to tell you, it could be a ticking time bomb if you're not careful. It's interesting to me, like if you go to some of these internet providers, and I'm an internet provider myself, but they will, after you make a purchase, they say, rate your experience, and you give it a 4-star rating because, hey, it was easy to do. I liked it. But that implies, because they will then use that 4-star rating saying, all our clients give us a 4-star rating, but you may get sued in 3 years and the template documents you provided just were not adequate enough to deal with the real world, Wild West that we have going on for us. The other thing I want you to be careful about is what I call beware the lemmings. I get this all the time. I'll tell people, well, if this is what the law is and this is what you need to do, and the immediate response back to me is, well, that's not what, others in my industry do. And I'm like, I don't care what the other people in your industry do. What I care about is you, not violating New Mexico law and getting yourself into trouble. And the number 2 thing that I'm going to talk about, a lot of lemmings there. So that's going to be a fun discussion in just a minute. Heather asks us, where do we find the information to ensure our businesses have what it needs? Heather, that's such a great question. There's really no one place for anything. And I know that's the most frustrating answer I can give you. But, if you are a restaurant looking for a liquor license, I'm going to give you a very different answer from somebody who's a transportation company transporting hazardous materials from point A to point B versus a doctor or medical professional. So you really need to talk to different people. I think SBDC has some really good consultants on staff that can point you in some directions. Being on a first name basis with the lawyer, CPA, and banker and talking to them about your business, they'll help point you in the right direction. But it is some investigation, unfortunately. So you do need to figure stuff out on your own to some extent. I also want you to be aware of what's called negligence per se. And I'm going to give you an example of my brother-in-law. He owns some fast sign franchises in Florida. And he said, hey, Larry, can you give me a contract that allows me to dig so that my customer is going to be responsible if I dig up a cable or break open a gas main? And I said, are you going to get permits for that? He's like, oh no, we don't do that. We just dig and we hope for the best. And I'm like, well, that's not a really good idea, because if you are required by law to get a permit and you don't, and then you dig up a cable, you expose a gas line and things explode and somebody dies, you are liable. It's called negligence per se. You are negligent because you violated the law. You automatically are negligent, and that creates some very high penalties and other problems for your business. So you definitely don't want to break the law, number one. And two, if somebody gets hurt, then you got a really big problem. So you want to make sure that nobody gets hurt, especially if you're not following the law as much as you should. And then finally, I want to tell you that poor decisions and bad behavior is eventually going to catch up with you. So don't do it. And, I've had a client recently, and he was just taking shortcuts. I don't know how else to phrase this, but he was taking shortcuts, and eventually he took a shortcut, one too many, and it affected one of his customers. And what happened was, in an expense event, I can't give you too much information, but it created some equipment failed. That failure, his customer was really upset about it, hired a lawyer. They figured out my client was cutting corners, and then tried to make it a class action lawsuit saying, we think you've been doing this to other clients as well. We want to talk to those clients. We want your customer list, and basically put them out of business, because then they created this bigger issue. So you don't want to have ongoing bad behavior. And just because maybe you got away with it once doesn't mean you're going to be able to get away with it in the future. And you really do need to avoid that. Now, some things, believe it or not, carry jail time. And it surprises people when I tell people this. But an easy one is, for example, providing services without a license when you require a license, right? If you try to be a lawyer, it's called unlicensed, practice of law. That could potentially carry jail time. Imagine trying to, pretend you're a doctor. And I know these seem like ridiculous examples. However, it's really interesting, because I will talk to nurse practitioners who want to move into telemedicine. And the laws have recently changed, making it a little easier, but laws require a human touch. They define what it means to have a face-to-face visitor meeting. And if you ignore those things, you could have a criminal sanction or penalty against you. So you don't want to do that. And obviously, and I mentioned the negligence per se, conducting any sort of illegal or unlicensed or permitted act, and somebody gets hurt. You could have potential criminal sanctions on that. And here's one that a lot of people find surprising: franchises. Now, saying the word franchise is a legal definition. A franchise has very specific components to it. So if you want to do a rev share, meaning you're going to have somebody else open up a business and they're going to pay you commissions because they're using your business model or your computer application or your processes or something, and they're going to share profits with you, guess what? That's a franchise. I don't care if you call it something else. That's a franchise, unless you have part ownership in that business. So if you do not have part ownership in that business, that's a franchise. And in some states, not New Mexico, but in other states, criminal sanctions. So you could be sitting here in New Mexico with your happy butt in the seat, forming a relationship with somebody in California, and guess what? You've committed a felony in California. So you really want to be careful about certain types of relationships, and you should consult the experts before you do that. I'm going to give you one real world example here, and that was an out-of-state contractor. This guy was from Florida, and he was doing expensive windows for a facility here in Albuquerque. And he went and got himself a business license from the city. And guess what? That's not a contractor license, but that's all people need to do in Florida. So he took his knowledge of the contracting business from Florida, brought it here to New Mexico and thought he was operating legally. And guess what? He put in, hundreds of thousands of dollars worth of windows in a building here in the Albuquerque area. And then his customer said, hey, wait a minute, you don't have a valid license. I'm not paying you, and you owe me because I had to hire somebody else to finish the work so I can get permitting. And so my client hired me saying, I have a valid license here. And so my project ended up being trying to minimize the harm that my client was suffering because he did it incorrectly. He wasn't very happy with me, by the way, because even to this day, if you dug him up and talked to him, he'd insist he was doing things legally, and he wasn't. He just didn't want to believe otherwise, but we were able to help him reduce some of his expenses a little bit, but he violated the law. There wasn't really anything that we can do aggressively to help protect him and at least get him his money for those windows. So it was a really bad circumstance and setup for him. Number two, improper classification of contractors. Remember I talked about the lemmings? A lot of people tell me over and over again, well, everybody in my business is a contractor. It just doesn't matter. So hopefully you know what these rules are, but I'm still going to explain it to you because over and over again, it seems to be a big issue with businesses. The general rule is that if an individual is, let me rephrase that. I'm going to read it directly. The general rule is that an individual is an independent contractor if the payer, that's you, the business, has the right to control or direct only the result of the work and not what will be done and how it will be done. So let me give you an example. I'm a lawyer. If I hire a painter, I can certainly tell the painter, paint this room, not the other room, and I want you to paint these colors. And oh, by the way, I have a webinar between 12 and 1, so I don't want you painting during that time. So the painter is free to figure out, where to get the paint, and he's going to provide the materials and all of that. That's easily a contractor. But if you change the rules a little bit, that person may not be a contractor. So let's say I'm a painter and I hire a painter to paint my office. Maybe that's a contractor, but if I hire that painter to paint somebody else's office, now that really looks like an employee relationship, even if that individual has other clients to service on his own. The fact that he's doing for me what I do as a business makes it really look like that individual is an employee. So you really got to look at these factors. Behavioral, does the company have the right to control what the worker does? Financial, how are the financial situations looking? Am I collecting money from a third party and then paying that contractor for the work that contractor does for that third party? Sure looks like I'm an employer at that point. And then the types of relationships, are there, contracts in place? Am I providing benefits? Will the relationship continue ongoing, or is it just for a certain duration? All of those things will, be factored in. Now, the one thing you need to know is New Mexico Workforce Solutions has even a more restrictive view on what a contractor is versus the IRS. So it's possible you may meet the IRS's test, but not, Workforce Solutions. So the general rule is if it looks like you're in control or the contractor, the employee is doing the same work you do as a business, Workforce Solutions almost certainly is going to say this person is a contractor. And here's the problem. If you get this wrong, you may owe back pay, withholding taxes, penalties, and interest for all employees and contractors that you may have violated the status. The IRS can impute unpaid salary or hourly wages for everyone. So I'm going to give you an example. I had a salon who had people, some people as employees, some people as contractors, and the contractors were able to come and go as they want. And they made there was an example of one contractor had stuff going on in the middle of the day. So he or she, I don't remember the gender, would come in the morning, service a couple of folks, and then come in the evening and service a couple of folks. And my client did not have a check-in and check-out system. So at any rate, the employees all got together and complained against my client, and my client didn't have the ability to argue or prove that these people were coming and going. And of course, remember, they were lying to the IRS saying, oh no, we were there the whole day. So the IRS said, that's fine. We're going to assume, we have evidence of them being there in the morning. We have evidence of their being in the evening. We're going to assume they were there the entire day. And it's clear what you've been paying them. So you owe them more money. And it was tens of thousands of dollars. And the problem is these employees talk to each other. So they all got on the same bandwagon and started arguing that they all need to get paid for back wages and overtime that they were never paid for. So it was a very expensive fight, and it put my client tens of thousands of dollars in the hole. So how do you get this right? Well, one is you can get a professional opinion by a business lawyer or a CPA. They can write a formal opinion letter. Now, that may not have the rule of God to it, but it's going to be hopefully honest and point you in the right direction. And if you do what's in the employment or the opinion letter, if you are wrong, meaning if the lawyer or CPA is wrong, you get to say, hey, I tried to do the right thing, and you shouldn't hold me to the penalties and interest at least. And that'll help you at least avoid some of the big costs associated with a wrong decision here. The other one is you can go to the IRS and ask for a formal opinion letter from them. But remember what I told you about New Mexico Workforce Solutions. So you may be okay with the IRS, but still not okay with Workforce Solutions. So sometimes it might be best to get an opinion letter as well as go to the IRS and see what they say. And I actually mentioned the example already with the salon's angry former contractors. They were all former employees and contractors. They all ganged up. They all filed complaints with the IRS, and it was a very expensive and in fact, he's out of business now. He had 2 or 3 locations, and it put him out of business, unfortunately. So let's do the number one issue of businesses, and it's leases. And I put inexperienced business owners here because it seems to me the inexperienced folks are the ones that make the biggest mistakes. But we do have problems with everybody, whether they're experienced or not. So what you need to understand about leases is the law on leases, commercial leases, you're on your own. There's no such thing as a slumlord. There's no such thing as, the law to protect you like you might expect in a residential setting. So everything you know and understand about residential leases, throw out the window as it relates to commercial leases. There's nothing there to protect you and, ensure that you're not getting, a bad, slumlord, or you get a bad situation. So you need to understand these things. The lease is everything. The landlord has an automatic lien on your property by statute, unless it says otherwise in the lease. There's no protection from the landlord or the neighbors chasing away customers with noise or odors or other problems, lack of parking, unless it's in the lease. So when a landlord says, oh, don't worry, I'll make sure you have parking, put it in the darn lease or you're not interested. There are no legal requirements, by the way, for heating or cooling, believe it or not, unless it's in the lease. We got another question here. I apologize if you already addressed this question. In regards to mistake number 9, aside from disengaging, what should a friend do to limit their liability? So I guess you're hiring a friend as a contractor and you want to terminate the relationship with the contractor. If I'm understanding your question correctly, you could form a separation agreement or a termination agreement where maybe you throw them a little bit of money and in return, they agree not to sue or do things. That is an option. Although note that there are certain things that you can't contract away. Gross negligence is one, violating civil liberties would be another one. So you got to be a little careful about that. And I hope I answered your question. And if not, give me a little more detail and I'll try to answer better. The other thing I want you to think about with leases is to avoid certain language. And I have a list here and I can't go through it in depth. We don't have enough time. But one thing is when you're prohibited from doing something without landlord approval, change it to approval that's not unreasonably withheld or delayed, for example. You want to remove ambiguity. And the other thing you need to understand is landlords can sell the property to somebody else. So if you have a really nice landlord that you like, and he or she is not really enforcing a lot of the terms, that's great for you. But you have a risk to the business because if they sell that property, the new landlord can enforce all of those things. And not only that, go back in time and say, wait a minute, the old landlord wasn't charging you for water. I'm charging you for water, but I'm also entitled to what the old landlord was entitled to. So you need to pay me for all the water that the old landlord didn't charge you. So you need to make sure that that lease is exactly the way you want it. And if the new land or your existing landlord's being nice, try and get them to put that in the document somehow to try and reduce your risks. Now, the other thing I want to mention, we get this a lot lately because of COVID, is how do you get out of a lease? And the answer is it's not very easy to get out of a lease at all. What you want to do is, look at the force majeure clause first. It's going to be near the back or bottom of the lease, usually on the last couple of pages. It's usually called force majeure or acts of God, and see what it says about that and or pandemics. Usually 9 times out of 10, it's going to say the parties can forbear performance, which usually means delay performance. A lot of times it's going to say, except for the payment of money. That's not going to help you out at all, but you need to look at that clause and see what rights it gives you. The other question is, are you an essential business or not? If you're not an essential business, the doctrine of impossibility or impracticality may be available for you. But it has some very specific requirements here that I have listed. And if that's important to you, you might want to get a copy of this presentation. But it basically says that the events have to be outside your control and that it's impossible for you to fulfill the terms of the contract, meaning open your business. So that might be available to you. And if so, it might give you the ability to terminate. But usually it's to forbear or forestall or delay. So usually this is a delay mechanism depending on the circumstances. The other issue is if your business is declined just because of COVID, that's not going to be covered under the doctrine. It's only if you're legally prohibited, physically prohibited from opening your doors. Then you can argue doctrine of impossibility or impracticality. But I always recommend negotiating with the landlord first. What we're finding is probably 70% of the landlords out there are willing to negotiate. And usually what's common is the landlord will be willing to say, let's delay payment of the lease, and then we're going to extend the term of the lease, meaning, so you're not going to have to pay me for the next 6 months, but we're going to extend the lease for 6 months so that I can eventually get paid for use being in my property. We see a lot of that happening, and we'd recommend, trying to have a good relationship with the landlord first. That's always going to be better than having a legal fight and having to rely on the terms of the lease. And the doctrine of impossibility does have these specific requirements that I've outlined here. Finally, I want to give you one real world example here quickly, and that was with a yoga studio. He was a friend of mine. He was an engineer from Sandia, had no idea how to open up a yoga studio or do business, but he really liked yoga and he wanted to open up a yoga studio. So what he ended up doing is subletting from an MMA gym. And I remember at the time, I begged him, I'm like, please do not do this. One is, I can't think of two opposite worlds. People that want to do yoga and MMA trainers and fighters. I think, Enya versus hard rock, acid rock. I felt like there'd be a huge culture clash, number one. And then two, it's a 10-year contract he was signing. I'm like, you don't even know how to run a business like this. Most businesses fail after 3 years. There's a very strong possibility this business is going to fail, and then you're on this hook for 10 years. So my friends like, Larry, I don't want to hear it. This is what I'm doing. He signed the contract. He let me review the contract, by the way. I totally rewrote it. The MMA folks said, no, take it or leave it. So my friend said, okay, fine, I'm going to take it and sign the contract the way it was. And sure enough, 6 months into it, the MMA folks were like doing things like blocking my client, my friend, from entering his premises because he had to walk through the gym to get to it. It was a terrible, terrible thing. Fortunately, though, we got some video of the violence, and we were able to argue that you created it in not just an unsafe environment, but you breached the agreement by prohibiting access to the premises. But we got lucky to get that video, by the way. And you can't expect to get video on bad behavior like this. So don't put yourself in that situation. Finally, I hope you're seeing a common theme here. It's regarding contracts. And contracts have a lot of, whether you're dealing with landlords or you're dealing with customers or you're dealing with partners, contracts are really important to get right. And then also, I just wanted to bring up, because we're in COVID, we have a lot of issues here. Make sure you have the right force majeure clause. Beware of shifting rules between jurisdictions, and then do what you can to help the non-essential businesses. We have a couple of minutes left. We have a few questions. One is, can the friend's liability be limited through the use of contracts? Is a lawyer necessary for these kinds of contracts? My concern is for the friend. Well, if you got a friend doing work, the question is, who is he or she doing it for? Do they have a partnership? Is there the law of agency involved? So you got to be really careful with who's doing the work and how and what kind of harms can develop. So is a lawyer necessary? No, but a lawyer is definitely going to be able to point you in the right direction. But in general, you want 3 things to limit liability: a corporation or LLC to do the work under to limit liability; 2, insurance; 3, contract. To use a crude metaphor, think of it as like trying to avoid pregnancy. No one method works perfectly, so you want to use multiple methods. Same thing with liability protection. Stan asks, can you recommend a standard but fair lease template that can be presented to a landlord as a start to negotiation, or do I need to consult a lawyer? That's a great question, Stan. And the problem is there's different types of leases. For instance, you might have heard of like a triple net lease. Are utilities included or not? Is there a common area maintenance or not? So the leases are very specific to the way the landlord manages the property and what's going on at the property. So usually the landlord is going to provide the lease, number one. And I would strongly recommend you have a lawyer, not broker, review the lease. And it's not very difficult. I'll tell you, when people have us do it, it takes us usually maybe an hour to review the lease and point out the problems. The bigger problem is the negotiation, because the landlords don't like to change those leases very much. So I recommend you don't just find one property that you like, but you find several. And then you also shop on the lease terms and conditions. That's the best way to make sure that you have a good lease with the right terms that you need. And I think we have about 1 minute left. Any other questions we can answer for anybody?
Larry, while we wait for answers, I'll just quickly let everyone know that I'm about to chat through some links to our website where you can find on-demand webinars and a list of upcoming live webinars that we'll have. We will make this webinar available on demand today, and I will also email you to let you know as soon as it's available. And then if you guys have any questions, you can email us at nmsbdcwebinars@sfcc.edu. And we will get back to you. And then, yeah, if you guys have any questions, feel free to ask them now. Raise a hand if you want to speak or put them in the Q&A. And then, Larry, if there's anything else you want to say, go for it.
I am good. I appreciate everybody joining us today. Thank you.
Okay.
Heather asked, is part one available to rewatch? And the answer is we're working on that. And the answer is yes, it will be available. It's just not ready yet. Probably within a week. And you can contact.
Yeah, and I actually.
Sorry.
Yeah, go ahead. Sorry, Larry.
No, please.
I was going to say it has since been made available on demand. So if you check our workshops and events page, you should see it on there. If not, email us and I'll be sure that you get it. And I will send through the links to the on-demand part 1 and today's webinar in the email that I send as a follow-up to you guys. Excellent. Well, thank you all for your attendance. And as always, Larry, a pleasure. And we look forward to having you again next week. And that wraps it up for now.
Thank you. Thank you, everyone.